Saran, Judge, Supreme Court of India, respected Madam Uma Saran, Honorable Dr. Justice S. Muralidhar, the Chief Justice, High Court of Orissa, Honorable Judges, High Court of Orissa, respected senior trainers on mediation, respected Advocate General Orissa, respected Assistant Solicitor General, Government of India, esteemed Registrar General and members of Registry, High Court of Orissa, respected Director, Odisha Judicial Academy, respected Member Secretary, Odisha State Legal Services Authority, respected participating judicial officers attending the workshop and trainee civil judges, distinguished guests, and members of print and electronic media, and all the respected guests watching the program live on YouTube. Pranam and a very good morning to everyone present in the August gathering. An ounce of mediation is worth a pound of arbitration and a ton of litigation. We are truly honored and privileged to have Honorable Shri Justice Vineet Saran, Judge, Supreme Court of India, amongst us in the inaugural session, along with Madam Uma Saran, whose gracious presence has added to the glory of the function. May I now have the privilege to request Honorable Shri Justice Vineet Saran, Judge, Supreme Court of India, to kindly adorn the dais, and I request respected Registrar General to conduct his lordship to the dais. May I now have the privilege to request Honorable Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly adorn the dais, and I request respected Director, Odisha Judicial Academy, to conduct his lordship to the dais. May I now have the privilege to request Honorable Shri Justice Chittaranjan Das, Honorable Shri Justice Vibhu Prasad Rautrai, Honorable Ms. Justice Savitri Ratho, Honorable Shri Justice Sashikanta Mishra, Judges, High Court of Orissa, to kindly adorn the dais, and I also request respected Registrar Judicial to conduct the honorable judges to the dais. May I now have the permission of the Honorable Chair to declare the function open. May I now have the permission of the Honorable Chair to declare the function open. Now the function is declared open. I now request Ms. Sushri Sai Priya Tripathi, Civil Judge on Probation, to present flower bouquet to Honorable Shri Justice Vineet Saran, Judge, Supreme Court of India. I now request Ms. Sharon Bastia, Civil Judge on Probation, to present flower bouquet to Honorable Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa. I now request Ms. Mallika Goenka, Civil Judge on Probation, to present flower bouquet to Honorable Shri Justice Chittaranjan Das, Judge, High Court of Orissa. I now request Ms. Sandhya Sucharita, Civil Judge on Probation, to present flower bouquet to Honorable Shri Justice Vibhu Prasad Rautrai, Judge, High Court of Orissa. I now request Ms. Sushmita Priyadarshini, Civil Judge on Probation, to present flower bouquet to Honorable Ms. Justice Savitri Rathore, Judge, High Court of Orissa. I now request Ms. Sarmishtha Padhi, Civil Judge on Probation, to present flower bouquet to Honorable Shri Justice Sashikanta Mishra, Judge, High Court of Orissa. May I now request Honorable Shri Justice Vibho Prasad Rautrai, Judge, High Court of Orissa, Member Mediation Monitoring Committee, to kindly deliver the welcome address. My Lord, please.
Pranam and a very good morning to everyone. Honorable Sri Justice Binit Saran, Judge Supreme Court of India, and respected Madam Mrs. Uma Saran, Dr. Justice S. Murlidhar, esteemed Chief Justice of High Court of Orissa, my sister and brother judges, Sri Ashok Parija, Learned Advocate General Odisha, Learned President and other office bearers of the High Court Bar Association, our distinguished resource persons and trainers of mediation program, Ms. Bina Rali, Mr. J.P. Singh and Ms. Swati Setia, officers of the registry, member secretary of Odisha State Legal Services Authority, the director, Odisha Judicial Academy, dear judicial officers present here, ladies and gentlemen. I am extremely overwhelmed to have this opportunity to extend a warm welcome on behalf of Odisha High Court to all the dignitaries on the dais and off the dais, and the audience of this August gathering in this inaugural event of 40 hours mediation training program for our judicial officers that is organized with a view to impart and enhance essential qualifications required for a mediator to able to be entrusted with the task of mediating the disputes. On this momentous occasion, we feel privileged to have with us my Lord Justice Binit Saran, Judge Supreme Court of India, our chief guest. And I may mention that our chief guest does not require an introduction. He is a well-recognized figure in the judicial sphere of our country, our beloved former Chief Justice and our guardian. I may take the liberty to mention that the High Court of Odisha always remembers Honorable Justice Saran with a feel of pride and affection. It is indeed my proud privilege to welcome Honorable Sri Justice Binit Saran and Madam Uma Saran, not only to this function, but to their second home state, Odisha. I will be short of words to describe Justice Saran, his Lordship's dedication and commitment for the overall development of the High Court of Orissa, who has never turned down any invitation extended to him to visit Odisha, and a consequent visit then to Mahaprabhu Lord Jagannath. I pray to Lord Jagannath to shower his blessings on him and his family. My Lord Justice Saran's period as the Chief Justice of High Court of Orissa was remarkable, and his Lordship is fondly remembered and will always be remembered for the immense interest taken by him for the development of High Court of Orissa. To strengthen the mediation system in Odisha, in the month of last November 2021, under the leadership and guidance of our Chief Justice Dr. S. Murlidhar, we had organized a 40 hours mediation training program for lawyer mediators. Our Chief Justice Dr. S. Murlidhar has further envisioned to make the object of mediation more productive in the state of Odisha, and has taken a laudable step to train the judicial officers so that it would be more beneficial for them, so also to the litigants, to resolve more and more disputes through proper mediation, which is going to happen for the first time in Odisha. Sir, I salute your overall vision, not only for the High Court, but also for the entire state judiciary and towards augmenting justice dispensation system in the state of Odisha. I extend a warm welcome to our leader, Dr. Justice S. Muralidhar, Chief Justice, without whose vision this program would not have been planned. I can say that every day and every moment he is planning something much better for overall development of the state judiciary in Odisha. And during his tenure of last 1 year and 3 months, the High Court of Odisha and Odisha judiciary has seen a great change and development in every sphere under his active guidance and leadership. At the same time, I must welcome all my esteemed sister and brother judges present here to make this event successful. I also extend a warm welcome to the resource persons and trainers from MCPC, Ms. Veena Rali, Mr. JP Singh, and Ms. Swati Satya, all the trainee officers. I welcome all the judicial officers and the dignitaries present here to this inaugural event, and I also welcome the members of print and electronic media for their presence. This training program, I believe, would provide a rare opportunity to the participants for such interactive enlightenments in the presence of all excellent mediation trainers. Once again, I welcome all of you. Thank you. Namaskar.
Thank you, my lord, for your kind words. May I now request Honorable Ms. Justice Savitri Rathore, Judge, High Court of Orissa and Member Mediation Monitoring Committee to kindly address the August gathering. Madam, please.
Namaskar. A very good morning to everybody. Honorable Justice Mr. Vineet Saran, Madam Uma Saran, Dr. S. Muralidhar, Honorable Justice C.R. Das, Honorable Justice B.P. Rautrai, Honorable Justice Shashikant Mishra, and my esteemed brother colleagues who are attending this function in person and through virtual mode, the learned Advocate General, the President, Secretary and Office Bearers of the High Court of Orissa Bar Association, senior trainers on mediation, officers of the registry, Director of the Orissa Judicial Academy and his team, Member Secretary, Orissa State Legal Services Authority and his team, judicial officers who have come to attend the training, other judicial officers, members of print and electronic media, ladies and gentlemen. Joseph Girbaum said it well when he said, an ounce of mediation is worth a pound of arbitration and a ton of litigation. The use of mediation to solve disputes is almost as old as civilization. As soon as Adam tasted the apple and his tribe increased, life changed and disputes arose. Mediation has evolved with civilization, and these could have only been effectively solved by mediation. In India, we had a panchayats. In fact, even now, people first turn to the panchayats for resolving the disputes, as the said mode is short and cheap, though the decisions may not always be ideal or acceptable. The Chief Justice of India set up the Mediation and Conciliation Project Committee in the year 2005 to encourage amicable resolution of disputes pending in the courts in accordance with Section 89 of the Code of Civil Procedure. The MCP initiated a court-integrated mediation process, which has proved very successful. Encouraged by the results, the MCP has conducted 40 hours mediation training program and other programs for the mediators. Our High Court framed the civil procedure mediation rules in the year 2007 in exercise of power under Part 10 of the CPC and Clause D of Subclause 2 of Section 89. Now, by way of amendment in Rule 4 of the Civil Procedure Mediation Rules 2007, a new sub-rule has been introduced as Subclause A rule 4, Roman 4, where all in-service judicial officers, irrespective of cadre, are to be trained as mediators. So, pursuant to that, now 30 of our judicial officers are going to be trained for the said purpose. And we are deeply indebted to Honorable Justice Saran for making it, for sparing his valuable time to come here for inaugurating this program. And for this purpose, I welcome all the officers who have come here to attend the mediation program and everybody for this program. Thank you.
Thank you, Madam, for your encouraging and informational words. May I now request Honorable Justice Chittaranjan Das, Judge High Court of Orissa and Chairman Mediation Monitoring Committee, to kindly address the esteemed gathering. My Lord, please.
My Lord, Justice Vinit Saran, Judge Supreme Court of India, Dr. Justice S. Muralidhar, Honorable Chief Justice, Odisha High Court, Dr. Mr. Vihu Prasanna Rautray, Judge Odisha High Court, Madam Savitri Ratha, Judge Odisha High Court, Justice Sasikant Mishra, Judge Odisha High Court, gracious Bhavi present here, my esteemed brother and sister judges watching the program virtually and here, esteemed trainers, officers of the registry, officers of the Odisha Judicial Academy, and the trainee officers present here, including the trainee civil judges. Rightly, Justice Vihu Rautray said that Justice Vinit Saran needs no introduction here. He was the patriarch of this institution for more than 2 years, and we still feel his presence here. And I would simply say, welcome to your home, sir. And always, when he comes, he used to have a hectic schedule, and guess whatever events we arrange, and don't say a word of no to any of the event we organize. The training for the officers, which was not there in the rule, is a novel idea envisioned by our Chief Justice. Mediation is a part of the judicial process. After introduction of Section 89 CPC. And always the retired judges, trained lawyers are not adequate. We as officers of the judiciary always take up mediation in Lok Adalat. But without any training. By our experience, by our ingenuity, by our wisdom, we take up mediation and succeeds also. Not that we fail always. But by this training, the wisdom of the officers shall be honed, and the methods for mediation shall certainly be sharpened. And this 40 hours training, I think, would go a long way for the officers who are going to be trained, and long way for the entire foundation judiciary. In the near future, as this program shall not stop here. We have learned from Justice Saran and from our present Chief Justice that for progress, speed is of not of much importance. Direction is of much importance. And when a direction has been given to the process of training for officers in mediation, I think it will go a long way to benefit the litigant and the judiciary. I wish all the success so far as the training is concerned, and hope that such training shall be commenced in near future in batches. Thank you.
Thank you, my lord, for your precious words. May I now request Honorable Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly address the august house. My lord, please.
A very warm good morning to everyone. Justice Vinit Saran, Judge, Supreme Court of India, and former Chief Justice of the Orissa High Court, Mrs. Saran, who has very kindly agreed to be here with her gracious presence. My esteemed colleagues on the dais, my esteemed colleagues present in the audience, Justice Sahu, who is present online, the Advocate General, Shri Ashok Parija, Shri P.K. Pari, the Assistant Solicitor General, all the distinguished guests who have come, the judicial officers present here, my registry officials, and most importantly, my very dear friends, Ms. Veena Ali, Mr. J.P. Singh, Senior Advocate, and Ms. Swati, the resource persons from Delhi, who very kindly consented to be the resource persons for this 40-hour workshop on training judicial officers in mediation. Delhi has, for a long time, been training its judicial officers in mediation as of the rest of the country. And I think in Odisha, this is the first attempt we are making at training judicial officers in mediation. On studying the pattern of pendency of cases in Odisha, I have found that the large number of civil cases are focused on the eastern districts of Orissa, running from the north to the south. And predominantly, these are cases involving family matters, commercial matters, but there is intensity of civil litigation in the eastern seaboard of Orissa. And there will be many reasons for that. Of course, there are some cities in the western Orissa, like Sambalpur also, which sees a lot of civil litigation. We have to encourage a culture of mediation in Orissa. We've opened the mediation center for the High Court. There are, of course, these permanent Lok Adalats for public utilities, which sort of do a kind of mediation. But largely, the lawyers here are used to adversarial litigation. And therefore, the judges to deal with largely adversarial litigation. They do attempt at mediation at the personal level in the chambers and family matters. The Family Courts Act itself encourages mediation. But mediation as a culture, as part of the whole litigation culture, is yet to grow fully in Orissa. So we're making the first steps after a gap of almost 6 to 8 years. We had the first mediation workshop for lawyers. We've had 2 sets of trainings, one for the Cuttack and the other for the Bhubaneswar lawyers, and this time for the judicial officers. As the resource persons will tell you, for being a mediator, you have to have a different mindset. And there is something to training oneself as a mediator. You could be an expert lawyer, you could be a senior lawyer, you could be a law professor, you could be very learned in the law, you could be very sharp in your advocacy skills, but mediation requires something else. First of all, mediation requires you to be completely objective and to recede, in a sense, to let parties come out with their stories. What mediation does is to enable parties to speak in their own voices. What happens is, you've heard of this phrase, lost in translation. You go to the lawyer, you explain your case to him, he then drafts a petition or drafts an affidavit. Very often the client doesn't understand what is written in the affidavit. The lawyer says, sign here, sign here, sign here. The party very faithfully signs it. When the party is in the box in the court and the lawyer for the other side is asking the party, did you really say this about your wife? Did you really say this about their husband? They're currently taken aback. And they're caught unawares. This is not what they meant to say about their spouse. But the lawyer has said it. Why? Because some decision under section 498A says that all these elements must be present if it is really going to be cruelty. So the lawyer decides, okay, all these elements must be present. So I'll make the person say it through an affidavit that my spouse did all these things to me. So not only did the real story not come out, some other story which is not meant to be even said has come out in pleadings in the court. And parties are stuck with it at the first level, at the second level. And a lot of bad blood comes out in pleadings, which was perhaps not intended by the parties. Then we have this necessary and relevant parties, correct? Proper and necessary parties. That concept in CPC, where you can only implead those necessary parties. A fourth cousin, an uncle's cousin, who may be very close to the family, a very close friend of the family, who can actually resolve disputes. They're all not necessary parties. They actually know more about the family. They know more about these people. In mediation, that is possible. When the mediators sit with the parties and ask them, who matters to you? Whose words do you respect? It may not be somebody in the family at all. It would be somebody else. That person can participate in the mediation. So mediation suddenly opens up the scope of who can be interested in resolving this dispute of this young couple or this middle-aged couple or this custody dispute. Children speak differently before mediators than they speak in court. Children come and see black gowns, coats, bands. JP wears all of that in court when he's arguing, and he's a total adversarial lawyer, I know that. But when he's a mediator, he's a very different person. You can't believe it's the same JP Singh. Likewise, as judges, we'll need to train ourselves to be different as mediators, where we shred our formality and we have an inclusive approach that anything will matter. Nothing is unimportant. In mediation, there's no relevant pleading and irrelevant pleading. There's no admissible evidence, inadmissible evidence. Those kind of concepts that we are trained in adversary litigation, we have to keep that aside, because in mediation, you open up your minds, you help parties open up their minds, and you recede only to the extent of helping them freely exchange their ideas and thoughts. I'm sure they will explain to you how this whole process evolves through mediation, and it requires enormous amount of patience. These mediators these resource persons are ace mediators. They have success rates of 80% and above. So they are among the best in the country who have come to train you, and they'll tell you that you need lots of patience. There's nothing called a failed mediation. Parties who've been through mediation have learned about each other more. And one of the ace mediators in the country, Mr. Sriram Panchu, has written a very nice book. The title of that book is Settle for More. Not settle for less, settle for more. So it's a very important phrase. You've learned more about yourself. You've learned more about the other party, other parties, and you've moved somewhere. Where you were at the beginning of the mediation will not be where you are at the end of the mediation. Whether the mediation succeeds or doesn't is a different point of view altogether, but you are not the same person. And I can tell you, each of you, when you mediate after going through this workshop, you'll find yourself to be a changed person. And I can assure you, you will not look at law litigation the same way. It helps you develop compassion. It helps you to be more understanding of people's problems, of what are called failures in life. Mediators don't acknowledge those words at all. There are no failures in life. Every person matters. Everything that the person feels matters. And that's what comes out in mediation. So mediation is a healing. It's supposed to heal wounds. It's supposed to bring out the better part of human beings. And in that process, it brings out the best in the mediator also. So it is a win-win all around in a mediation workshop. And when you carry forward the mediation in your judicial careers, in your professions, you'll find that you can use it in all kinds of situations, not necessarily family matters or 498A kind of situations. You'll be able to use it across the board, even in commercial matters. So I'm sure the judicial officers here are going to benefit hugely from this workshop. This will be the first of the kind of workshops. We'll have more and more workshops so that every judicial officer in the Odisha judiciary is trained in mediation. Thank you for coming here in such large numbers. Thank you for participating, and very, very deep gratitude to Justice Saran for being here with us on this momentous occasion. Thank you. Pranam.
Thank you, my lord, for sharing your valuable thoughts. May I now have the privilege to request Honorable Shri Justice Vineet Saran, Judge, Supreme Court of India, to kindly inaugurate the workshop by delivering the keynote address. My lord, please.
Very good morning to all of you present here. Brother Muralidhar, the dynamic Chief Justice of this Odisha High Court. My sister and brother judges on the dais and off the dais. The learned Advocate General, Mr. Ashok Parija. The learned ASG, Mr. Prasanna Pari. President and office bearers of the Bar Association. The trainees and the resource persons of today's event, Mr. JP Singh, Ms. Swati, and Ms. Veena. Judicial officers present here, members of the registry, ladies and gentlemen. Well, I would like to begin by saying that mediation is something like a movement which has begun a decade or decade and a half back in this country. It'll take its own pace, it'll take its own time, but I'm sure with the growth of this process of mediation, a lot of litigation can be resolved and a quietus can be put to the entire litigation through this process. Mediation is not new to this country, as has already been pointed out by Ms. Ratho, Justice Brother and Sister Justice Ratho. It's been here in this country since ages. The panchayat process, the panchayat is nothing but a process of mediation which we've always had. That's only to be now slowly and gradually with the courts coming up and all. The panchayat system of mediation is taken a back seat, but this system has to be revived, and I'm glad that all over the country and more so over here, strong steps are being taken to encourage mediation, and this workshop is an indication for that. Mediation is important because it involves the parties who are litigating, who are at loggerheads, and a solution is to be brought out by suggestions which are given by the parties. A mediator is only there to facilitate such solutions coming from the parties. There's a difference between conciliator and mediator. Conciliator suggests terms of settlement, whereas mediator does not suggest any such settlement. The settlement terms should come out from the parties themselves. Well, judicial officers are here who are to be trained as mediators, and I wish them all the best. One piece of advice I would definitely like to give to the judicial officers while being trained as a mediator and while acting as mediators would be, of course, that the resource persons and the trainers would be better able to suggest. But my advice and suggestion would be that when you act as a mediator, you should forget that you are in a position of authority. As a judicial officer, you always feel that you have the authority, you will decide the case, you'll do this. But as a mediator, you must know that that authority is not to be used and not to be used at all. The normal temptation while being a mediator as a judicial officer would be, all right, if you don't agree with this, I'll see you. I'll decide it in court. No, that should not be the attitude. The attitude should be that, all right, you hear a person, maybe probably as, I being chairman of mediation committee and some member at one particular time attended these mediation workshops. The idea should be that you hear the problems of one of the parties separately, the other parties separately in different rooms, and then make them sit together and hear their problems and let them solve it. So that is how it should be, rather than suggesting or using your authority. Of course, there are two school of thoughts. One, judicial officer mediators and other advocate mediators or retired judges mediators. I mean, they have the same role, but they have to be trained, and they have to be, of course, the trainers would know it better. Their training has to be in a slightly different manner for judicial officers and advocates that, of course, they have been training, so they would be knowing better. Another thing which is important is that there should be total confidentiality in the process of mediation. What the parties say to the mediator is not to be disclosed to the other party. And in any case, the mediator cannot and should not be required to depose in the court as to what transpired during the process of mediation. So the confidentiality part is a very important part. And all that you have to say is that the mediation, in the end, that the mediation has been successful in the process. With the mediation process, the matter has been decided in this manner, not decided, agreed and resolved in this manner. And if it is not successful, you're not to give reasons as to why it is not successful and who was responsible for it not being successful. All that you have to say is mediation failed or mediation not successful. That's one of, because because it should not prejudice. The report of the mediator should not prejudice the court when it goes back in case if it is not successful. Well, there's a difference which I've just noted, that in adversarial system and the mediation, the goal in adversarial, the court judicial system would be, the goal is to win the case. Whereas in mediation, it is to reach at a mutually accepted solution. That should be the idea. The style in adversarial system is argumentative, whereas in this mediation process, it is felicitative. The style of speech is to establish and convince the court, whereas in this process, it is to explain. And when you listen, it is to, when a lawyer listens, it is to see the flaws and develop counter arguments, whereas in mediation, it is to understand. The whole idea of mediation is that the whole dispute is resolved once and for all. The main benefit is, with this, you put a quietus to the litigation, there is no appeal, no revision, no further process. So if things are resolved through your efforts as a mediator, it would not only bring down litigation, but it would also resolve the disputes and the parties would come to terms and probably the relationships would be much better. Mediation is most successful where two parties are litigating and their personal relations are there. But it can also be quite successful in this. This is the kind of process which the Chief Justice just suggested, that 498A proceedings or divorce and family matters and all. But mediation can also be quite successful in corporate litigation. These litigations are very important to be resolved through mediation, because a lot of money is spent in litigation, which through mediation, if it's resolved, it would be much better. Well, in the end, I can only say that I wish all the best for this 40 hours mediation workshop, which under the able guidance of the Chief Justice and other committee members, as well as the trained mediators and resource persons, the trainers, Mr. J.P. Singh, Ms. Swati, Ms. Veena, and others of this High Court, will definitely be successful. And I wish all the best to all the participants and all the trainers. Thank you very much. Jai Jagannath ji.
Thank you, my lord, for your illuminating words and advices. Now, I would humbly request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to present the memento as a token of respect and gratitude to Honorable Justice Vineet Saran, Judge, Supreme Court of India. May I now request Honorable Shri Justice Sashikanta Mishra, Judge, High Court of Orissa, to propose the vote of thanks. My lord, please.
Namaskar and a very good morning to all. Esteemed dignitaries on and off the dais, participant judicial officers, ladies and gentlemen. Training of mediators, and particularly the 40 hours training program as designed by the MCPC of the Supreme Court of India, is nothing new. It has been happening for quite some time in our country and also in our state. In fact, as pointed out by some of the speakers, very recently we had a 40-hour training program for advocate mediators. But what is unique about today's program is that for the first time, judicial officers will be trained as mediators. This event assumes even all the more importance and significance, considering the fact that it has been graced by Honorable sitting judge of the Supreme Court of India. As pointed out by Brother Justice Rautrai, my Lord Honorable Justice Vineet Saran needs no introduction. And I'm sure everybody will agree that Odisha occupies a special place in his heart. And so does he in every person who has come in contact with him. So first and foremost, I would like to express my sincere gratitude to my Lord for his kind presence, for his illuminating address, and for his very valuable advice to the judicial officers who are to receive training as mediators. I also thank respected Madam Saran for her gracious presence. As I had said, this is a unique event. This is for the first time the judicial officers are being trained. And as pointed out by Honorable Justice Savitri Ratha, the rules had to be amended. So the entire brain behind it is Honorable the Chief Justice, Dr. Justice S. Muralidhar. And this is one among the many numerous steps that he has been taking ever since he has joined to develop the, let us say, the standard of judiciary in the state of Odisha. So thank you, my Lord, for your able guidance and leadership. I also thank Honorable Sri Justice Chittaranjan Das, the chairman of the Mediation Monitoring Committee, for his kind presence and address. I thank Honorable Justice B.P. Rautrai, member of the Mediation Monitoring Committee, for his presence and address. So also I thank Honorable Justice Savitri Ratha, the Judge Odisha High Court and member of the Mediation Monitoring Committee, for her presence and address. I thank all the honorable judges of the High Court who are present here and who have joined virtually for their kind presence. I'm sure your presence will serve as a source of encouragement for the judicial officers. I thank Sri Ashok Parija, Learned Advocate General, Sri Prasanna Padhi, the Assistant Solicitor General of India for the High Court of Odisha, for their presence. I thank the President and Secretary and other office bearers of the Odisha High Court Bar Association. I thank the senior mediation trainers who we are given to understand are among the best in the country for their kind presence here. And I'm sure over the next 40 hours or the 5 days, they will be imparting their valuable inputs, guidance, and advice to the judicial officers. I thank the members of the registry who, as usual, have toiled very hard to make this program a success. I thank the director of Odisha Judicial Academy and his team, the member secretary of State Legal Services Authority and his team, and also the judicial officers who are present here from 5 different districts of the state to be trained as mediators. And I'm sure as the tone has been set by Honorable the Chief Justice and by no less a person than Honorable Justice Vinit Saran, when he has given valuable advice to you as to how to conduct yourself as mediators rather than as adjudicators. So I thank you for your presence. I also thank the trainee judicial officers who are present here. And last but not the least, I would like to thank the friends from the print and electronic media for their continued support and for carrying forward the message of judiciary to the common man. Thank you, everybody. Jai Jagannath.
Thank you, my lord. May I now seek the permission of the Honorable Chair to declare the function closed. The function is declared closed.